All right, good morning.
Good morning, Professor.
We start? Yeah, we start? Okay, good. Welcome back, everyone. Hopefully you have a nice day so far. Okay, let's see. Any questions? Scott or Plessy, anything on your minds? We start? We good? Thank you. All right, everyone ready? All right, so any questions lingering in your minds? No? Okay. So today's class is going to be the continuation of last class, as it often is. In the last class, we did several cases that focus on segregation. These are cases before and after the 14th Amendment were ratified. We discussed Dred Scott, of course, which held that those of African descent could never be citizens of the United States. We discussed the 14th Amendment, which one would think would have nullified Dred Scott. But that brought us directly back to the case of Plessy v. Ferguson, where the court established this doctrine that became known as separate but equal. And I'm sure you study this in various parts of your education. But what we learned here was that the Supreme Court was actually trying to craft a rule that could fit within the terms of the 14th Amendment, but not result in widespread social discourse and social upturns. Okay? This doctrine would exist for almost 60 years. What we see in today's classes is a continuation of these doctrines. And specifically, how was it that the Supreme Court danced around the issue? I think what you'll find by looking at the cases today, Cumming, Giles, and Berea College, none of these cases actually addressed the constitutional issue. They all were tap dancing around the fact that states were segregating their schools or their voting rosters. This was a very deliberate effort by the court not to sanction or endorse the Plessy doctrine or extend it. And in each case, they found a way to avoid the issue. Of course, that avoidance only lasted so long. And by the time 1954 rolls around, with Brown versus Board of Education, the court avoided the issue no longer. But I think what you'll find, and this probably surprised you, was that Brown was an underwhelming opinion. It didn't say Plessy versus Ferguson was wrong. It didn't even reverse Plessy. It was a fairly short opinion. I know it's short in your book. It wasn't that long in the actual reported version. All it said was that there cannot be segregation in public education. It said nothing more about segregation in places of public accommodation and employment, etc. More striking, and this probably really surprised you, it didn't say at the end of Brown, desegregate now. They took a second case known as Brown 2, where they heard more arguments on the issue, and they said the schools would desegregate with, quote, all deliberate speed. Right? What does this mean, all deliberate speed? Well, it took a long time. So even though the court was pronouncing that segregation cannot exist in public education, it didn't do much to immediately remedy the problem of segregated schools. And we'll see afterwards how there was active civil disobedience and how many states openly said, we will not comply with this ruling because it's wrong. And then it brings us to cases that we studied in the past. We did the civil rights cases in 1964, parts of Atlanta, right? Ollie's Barbecue, remember Katzenbach? And I think what you'll find, and this is going to totally blow your minds, but it shouldn't, is that the courts were not the primary change, right? It was actually Congress and the president acting very wide-ranging civil rights laws. That's what actually did it. So as much as we glorify courts and all that they do, they were merely tagging along. It was momentous, no doubt. But the heavy lifting was not done until much later, with various Civil Rights Act, which prohibited discrimination in employment, business, schools, etc. So a lot of the conventional wisdom you've been taught about these cases is amplified, if you will. But in class today, I think we'll discuss what actually happened, the chronology with which it happened, and how long it actually took to get there. All right. Any questions before we get started? Yes, sir.
You mentioned about round 2, and I read, it did say speedy. Exactly.
All deliberate speed.
All deliberate speed. I'm from a small town out, 2 hours west of here, and they didn't desegregate the schools until the 70s.
No, they didn't. We'll talk about that like in about 30 minutes, okay? We will get that. And as a preview, there were school districts in Virginia that shut down. Rather than desegregate their schools, they just shut down their public schools. Didn't even open them up. They handed out tax credits, mostly to white kids. Say, okay, go to a private school. But they said, we will not operate a desegregated school. I'll show you another picture, right? There was another case called Palmer versus Thompson. Okay? This was a case of follow-up to Brown, where a federal court ordered a swimming pool in Jackson, Mississippi to desegregate. This is what they did to the swimming pool afterwards. They filled it with cement. So rather than open up the swimming pool to everybody, they filled it with cement. Okay, we'll go through this later, but you're absolutely right that this was not a speedy endeavor. Okay. All right. So any other questions before we get started? Okay. Where did I finish last time? Somewhere here. Yes, ma'am. Okay. So I'll call you in a minute, Mary, but you're up in a minute. Okay. So the first case we do, Cumming versus Board of Education, right? This was not a constitutional challenge. Okay. So there was a school district in Georgia. And the school district said, you know what? We're funded by tax dollars. We only get so much tax dollars to spend. We're not going to make a high school for blacks. Okay? One point to make very clear. This was not a constitutional challenge to the school's policy, right? Mary, why do you think this was not a constitutional challenge to the school's policy? Why do you think under prevailing law that wasn't brought? Again, this is an 1899 case. Why do you think the African Americans in this community didn't challenge this as unconstitutional? No. Why didn't the plaintiffs bring a constitutional challenge? Yes, why did the plaintiffs not bring a constitutional challenge?
Because they didn't have an issue that was separate.
Oh, I'm sure that an issue. But why do you think they didn't bring a constitutional challenge in your 1899? Why? No. What, Joe, what do you think? Why could they not bring this case as a constitutional challenge?
Because they weren't citizens?
No, they were citizens. 14th Amendment. What do you think? Anyway, why did they not bring this as a Crystal?
They didn't violate the provisions of the amendment.
Says who? What said that this didn't violate the 14th Amendment? Plessy. What you have to remember, this was decided about a decade after Plessy. Plessy versus Ferguson, 8-1 decision, right? It wasn't close, 8-1 decision. This was the controlling law of the United States of America. If they would have brought a challenge to this discriminatory policy saying that violates the 14th Amendment, Crystal, what would have happened? What would the court have said? What would the court have said if they brought a challenge saying this violates the 14th Amendment? Because of Plessy, right? They would have lost their case in 5 seconds. This is always whenever I help moot court students, right? If anybody come talk to me, someone always says, well, maybe I should ask the Supreme Court to reverse the precedent, right? That is never the right answer. If you go up there and say, Mr. Chief Justice, you were wrong. 8 justices of this court were incorrect. You need to reverse this and reinterpret the 14th Amendment. You're going to lose, right? You're going to lose. Because we have something called stare decisis. Courts stand by their precedents. They stand by their decisions. So what happened was, and this is the facts in Cummings and Giles and Berea College, is that the African American community tried to think of different ways of challenging segregation, right? They couldn't hit it head on, apply directly to the forehead, right? They couldn't go head on under the 14th Amendment. They had to take a circuitous route. They had to kind of attack it from the collateral, right? So Hector, what was the nature of the challenge? How did the members of this community decide that they would attack this policy without going right to the 14th Amendment? Yes. So talk about the tax issue for a moment.
Well, everybody was taxed for school, so I think their argument was something along the lines of since we taxed for the schools were entitled to have schools.
Okay. So right. So what they said was basically, listen, we're all paying the same taxes, right? How is it, fair that you're getting a high school for white girls, but there's, by the way, the schools were gender segregated too. This should have been maybe obvious in the case, but they weren't just race segregated. They were male and female high schools. So there was a girls' white high school, but there was no high school for African Americans, right? Now, this is a grievance that goes apart from discrimination, right? Taxpayers all the time complain, why you're giving all the money to this place and not to this place, right? So for a moment, let's just put aside the fact this issue about discrimination, which it does. But Connie, generally speaking, what's the remedy, right? If taxpayers complain that money's not being spent in a in a fair way, what's the usual remedy? Yeah, in a county, right? In a county that the Harris County is not spending their money fair. What's the usual remedy from taxpayers?
The school board would look at that and hopefully they would figure that out.
So political process, right? You lobby the school board, you lobby the state legislature, you lobby the city council, whatever, right? Can you go to court and sue over the fact that this, county's not putting enough money to a specific cause?
Well, I guess they did here.
No, but I'm saying in general, can taxpayers go to court and sue because they don't like how the government's spending their money? Wow, you guys are such lawsuits. The answer is no, right? The answer is no, and it's a pretty emphatic no. In our federal system, taxpayers almost never are standing. Under Texas law, there are some small circumstances where taxpayers have standing, but they're very slim. Generally, if you have a grievance with how the political machine is spending your tax money, your remedy is at the ballot box, right? You can vote at the school board, right? You can vote at the city council, whatever. So totally apart from the issue of race in this case, generally speaking, courts don't have any, business deciding how legislatures should spend their money, okay? But let's take this one step further. Vicky, let me ask you this question. In this case, were the African Americans saying that they had to spend money on a school for them? What were they actually saying? What was the specific claim they made?
I think they were saying that they weren't evenly distributed.
Yes. So to be very precise, what they were actually arguing was that money should not be spent on the white girls' high school, right? At the time, a court couldn't force a school to pay money to open up an African-American school. That wasn't even feasible, right? So the only extent of what they call a bill of equity, they're asking for equity, is to stop funding the white girls' school. Everyone see that? So again, because they couldn't challenge us directly under Plessy, because they were going to lose, 8-1 probably, except for Justice Harlan, they had to try and find a creative way of saying, okay, let's make tax money fair, and the Georgia Constitution requires, uniform education. Why don't we tell the cities how to spend their money, right? So everyone get the general gist of why it was a creative argument, right? They're saying, how do we tackle the issue, right? They were even arguing for integrated schools, right? They just wanted separate schools. They actually wanted a high school for African Americans to exist. They weren't even asking to learn together. They wanted a separate building to be built. All right. So Aleda, what did the court? And by the way, this was Justice Harlan. He was the Plessy dissenter, right? He wrote the majority opinion here, which is significant. But what did Justice Harlan say to the court, Aleda?
He said that the education of people in schools maintained by state taxation was a matter belonging to the states, and that any interference by the federal government,
By the federal courts. Yes.
the federal courts onto the management of them couldn't be justified, except if there was like some sort of hostility taking place in the town.
Yes. Okay. So it's a very curious opinion. Again, it's by Justice Harlan. He was a solo dissenter in Plessy. And Justice Harlan says, listen, it's not for the federal courts to get involved in micromanaging how counties spend money on education, right? And he makes a point even clearer. The only thing that we could do would be to say that the money being spent on the girls' high school was not proper. And that would result in shutting down the girls' high school. Maria, would that require them to build a school for African Americans? Absolutely not, right? That's what Harlan's saying. Is like, listen, my hands are tied. The only thing that I could do here is say, you cannot spend money on the girls' high school. And are we really prepared to shut down a girls' high school, knowing full well they will not build a high school for the African Americans, right? It's like this perverse dance around segregation, right? It's like there's this huge elephant in the room, and they don't want to acknowledge that it's there. So they're doing this little, like, elaborate circle around it. Okay. Now, what's significant, though, is what this opinion did not say. Okay. Whitney, what could this opinion have said were it not authored by Justice Harlan? What would have been the really easy way of resolving this issue? What could the opinion have said for getting about this tax issue? Think about it. What could a worst case scenario opinion have been here? What do you think Georgia argued here? What was Georgia? Do you have it? What was Georgia's position in this case? What was the state's position? Tiffany?
That it was impracticable to distribute taxes equally.
Because what did the Georgia Constitution say? They quoted at the beginning of the opinion.
That there should be a common schools for education in the elementary branches.
But
But they're separate schools.
yes, exactly. The Georgia Constitution incorporated Plessy. The Georgia Constitution says there will be public common education, but, quote, separate schools shall be provided for the white and colored races. That was in the Georgia Constitution. Imagine if the court had said separate but equal, right? There's no obligation to give African Americans high schools. Under the Georgia Constitution, they say you get education up to whatever primary school. Beyond that, there's no obligation to do it. That opinion would have been really bad. So actually, Harlan's opinion does this, I said, this elaborate dance, right? It doesn't extend Plessy, it doesn't expand it, but also doesn't reel it back. Yes, ma'am.
Wouldn't that mean, or I'd say actually one separately, one that needs to be different, like not have a high school for white?
Well, what's interesting is they say elementary, right? They're only required to give education for elementary school. So anything beyond that is not actually a constitutional right under the states. They wouldn't be required to give any. So you're right? So in theory, at least, if you do make one high school, you have to make the other. But under the Georgia Constitution as it's written, there was an obligation to give any high school at all. So this was merely a matter of how local counties spent their tax dollars.
So would consider higher education?
Something like that. Yeah, the Constitution only speaks to elementary. But you're probably right. You're probably right even if you take Plessy as written, you would say, well, if you have a white train car, you have a black train car, right? You have a white high school, you have a black high school. But Georgia effectively said, because we don't actually have to give high school, we just give elementary education, right? We have compulsory education laws today, which requires K through 12. I'm sure all of you are aware of this. That didn't exist. I mean, you're here, went through 12 years of education, right? That didn't exist throughout much of the 19th and even parts of 20th century. You generally had to have maybe an elementary education, 5th grade, if that. So you're right, but Georgia effectively could have argued that having them separate is okay. And the Berea College case, we'll do in a few minutes, proves that point even stronger. Okay? So everyone see, the opinion was bad, but it could have been worse. The court engages in this kind of, how do I say, dance around the issue. And I've asked this question before, I'll ask it again. Cindy, what do you think would have happened if the Supreme Court ordered this town in Georgia to build a school for African Americans? What do you think would have happened? Well, they would have ignored it for one, but yes, I think there would have been riots and it would have gone ignored, right? So again, it's really easy to judge his opinions, but at the time, I think the Supreme Court recognized that they did not have any power over this. That had they ordered the schools to, had they ordered a county to build a school, I mean, they would have been laughed away. It would have been just flatly ignored. And this is a theme we've discussed over and over again. When people start ignoring courts, we're in trouble, right? When courts are ignored, we get to serious civil problems. Yes.
Wasn't he the same judge that just said in Plessy, if we start saying it, they'll start doing it?
Yep, he did.
Sort of contradicted himself.
So yeah, so this is one of the contradictions of Harlan, right? And it's no mistake that he wrote the majority opinion. I think what he was trying to do was stem the damage. He was trying to prevent an opinion that expanded Plessy. This was roughly a decade after Plessy. I think he was trying to be very deliberate, not to have an opinion saying there's no need to even give high schools to African Americans. You see what I'm saying? Like, that could have been the opinion. Plessy was the starting point, right? They could have actually gone beyond that. And this was a question Alana asked a minute ago, right? They could have actually said, train cars are a public accommodation, but since there's no obligation to give high school, period, those only have to be equal. You see? They could have actually gone further.
When we're looking at Tawny versus Harlan, would you say that you can see based on how broad or narrow they choose to extend?
That's an interesting point.
Kind of, in a sense, manipulating.
Oh, what do you mean broad or narrow? You're on the right track. What does it mean broad or narrow?
So Tawny took a really broad.
In Dred Scott, right? Talking about Dred Scott? Right?
He wrote Dred Scott and he even covered all of these issues that he really didn't have to cover.
Right.
And here, the way that I read it based on Harlan's other opinions is he took a very narrow reading
Yes.
and didn't address some other issues, so he didn't have to.
Use this word manipulate. What do you mean manipulate?
Well, by not addressing them, he doesn't have to say, this is what the Constitution requires, or this is what stare decisis would say. He doesn't have to follow Plessy.
So you zeroed in on a very important aspect of the Supreme Court. They only address the issues they want to. And they can leave a lot of issues unresolved. Or they can overreach and address issues maybe they shouldn't. And I think you're exactly right. One of the lessons learned from Dred Scott, and by the way, Justice Harlan hated Dred Scott. And I told you he taught constitutional law at George Washington. I transcribed his lecture notes. They're really interesting. He would ridicule this opinion, saying it was such a mistake, it was such a judicial hubris for the court to reach such far. So what the court's doing here is baby steps, right? Maybe one step back, but it's not 5 steps back. Maybe half a step forward. By resolving this issue on the narrow grounds of this tax thing, he's allowing the local communities to keep, some sort of power over how they manage their schools, but he's not having a constitutional holding that there's a right to segregate schools, right? He did not say, yes, you can segregate schools because there's an obligation to give schools in the first place, right? If you have rail cars, yeah, then you have to make them equal, but if you don't have the power to give schools. Do you have a follow-up?
Yeah, I find it's just kind of brilliant that they've been doing that since Marshall.
Oh,
They
Marshall.
found that he started that.
Marshall didn't invent this. This is long before Marshall. There were British judges for centuries before him.
Okay, I just thought, because the first time we read that, I was like, That's super smart. You kind of tricked everyone.
Well, he didn't trick anyone. You guys are smart, right? You figured out what's going on. But this is you'll find this, I mean, and I don't say this as a cynic or a critical person, but judges have within their leeway the ability to resolve cases in a broad or narrow fashion. And by resolving a case on a very narrow ground, they can avoid riots. But the word used, manipulation, is not I think that's in the ballpark of a fair way to call it, because they're not just being neutral umpires, if you will, and resolving issues that come before them. I saw someone else's hand, I think. Anyone else? Yeah.
Just generally as a matter of construction, if a court mentions a lower holding and doesn't address it, but decides it on another ground, what does that mean?
Be more specific. I think I know what you're asking. Be a little more specific.
Well, I don't know if I have an example in this case, but I mean, sometimes.
Well, I'll give you an example. Was Plessy cited in this case? No. You'd think, right? A case about segregated schools. Decided, what, 10 years after Plessy? Was Plessy cited here? What's the significance, Hector, of not citing Plessy?
I mean, that's kind of my question.
I know it was. That's why I asked it. What's the significance of not citing Plessy in this case?
I mean, I think if you ignore a case, generally, you give less significance to it.
Right. So Harlan was no fool, right? He was a very smart man, and he was very well read in the law. And he knew when he wrote his dissent in Plessy that one day it would become a majority opinion, right? He knew one day that Plessy was not long for this world. So by not citing it in a case where it's directly on point, I mean, I said this a couple minutes ago, but you could have written an opinion saying, see Plessy plus this, right? You could pile it onto Plessy, right? They did not do that, which was extremely significant, because now this gives some hope to, various lawyers in the civil rights community saying, well, they didn't cite Plessy here. This is like, not quite progress, but we didn't go forward. We're still. And this began the process of trying to chip away at Jim Crow through the courts. So this is mentioned in your book, but one of the leaders of this was a lawyer by the name of Thurgood Marshall, who would later go on to serve in the U.S. Supreme Court. I have his picture here. It's got one in the middle. And he was the head of the NAACP Legal Defense Fund. This was the group that would try to litigate various civil rights issues in the courts. And they were really smart guys. They did not say, okay, day one, let's overturn Plessy, right? They were smarter than that. They said, we need to do this methodically. We realize we're not going to get the Supreme Court to go back on Plessy overnight. We need to have a series of cases that challenge in different ways various aspects of Jim Crow, right? We can't go straight at it because we'll lose. So this tax issue in the first case, the Cumming case, this was one strategy. Okay? It didn't work, right? This was not a success, but they at least had the small victory of not expanding the Plessy doctrine. They left it as is. Okay. The next case, Giles versus Harris, was another effort, okay, to challenge Jim Crow. Where was I? Jocelyn, what were the facts in Giles? Okay. Yes.
In order, and it's sort of the way that it went, it's like the passive right, part of the Constitution.
Yeah.
All like 40 years.
Yeah, right.
So the way it was set up, it kind of excluded mostly black people.
Right. Okay, good. So here's what happened, right? We have 15th Amendment. We studied this. 15th Amendment says you cannot deny the right to vote based on race. Okay, fine. So a state can't pass a law saying that only whites can vote. That would have been facially unconstitutional. So the state of Alabama decides, all right, we're going to be creative here. We're going to make this entire policy. If you were registered to vote before 1903, congratulations, your grandfather, you can keep your voting card, right? If you're not registered to vote by 1903, you need to jump through a series of hoops, one of which was you need to be able to write and read any article of the Constitution. You need to be able to be lawfully employed for 12 months, so I guess you can't be poor. You need to own 40 acres of land. That's a fairly sizable lot. You need to have assets of a few $1,000s, et cetera, okay? It shouldn't surprise you, and it won't surprise you, that these provisions were not enforced equally, where I'm positive that if a white man who was not employed went to go register to vote, he would have gotten a voting card. And if a black man went to go vote, he would have been set to recite the entire Constitution, which I can't even do, and have all these literacy requirements, right? So they did not challenge this as discriminatory, right? Jason, did Mr. Giles say that this voting regime is unconstitutional, that they can't impose these requirements of having to read the Constitution on property? Was that the nature of his challenge?
No, he was just questioning the.
Why did he not go up and say straight up, you cannot impose these literacy requirements, these property ownership requirements? Why did he not say that? Again,
Because he was literate and had been able to vote for 30 years.
why didn't someone else? Okay, why didn't someone bring a lawsuit? Some person who was not literate or couldn't own property, right? Why didn't that person bring a challenge saying that it violates the 15th Amendment and my right to vote because I can't have property, right? Why didn't he do that? Same as before.
The 11th Amendment not allowing you to.
No, he could. Alejandro, what do you think?
It doesn't specifically say in the 15th Amendment that you can't.
Was he going to win that case?
No.
He was going to lose. Okay, so what you're starting to sense here is they didn't want to bring a constitutional challenge they would lose because it could make stuff worse. It could make stuff worse. Okay, Alejandro, how could this case have been worse? Right? What could the Supreme Court say to make this really bad? What was like the worst case scenario here? Imagine Justice Taney back from the dead writing majority opinion, right? What would the opinion have been?
We could have just said, too bad.
No right. Yeah, the right to vote doesn't matter.
Yeah.
Think about it. The court could have said, as long as the law doesn't say whites can vote, blacks can't, it's constitutional. Any literacy requirement, any property ownership requirement, those are all constitutional. That would have given a green light to every single state to impose this exact regime. So in the same way that Morgan said that judges manipulate what they decide, plaintiffs manipulate what case they bring, right? Plaintiffs do not bring a case you're going to lose. This is the first rule of lawyering, right? Don't bring a case that you're going to lose because you're going to make it worse for everybody else. They did not want to bring a case where the Supreme Court says, oh, by the way, these literacy requirements are valid, right? These requirements of owning property, yeah, those are valid too. So they tried to do it on, like on the side, so to speak. Sean, what was the nature of the case Mr. Giles brought? What did he actually argue? What happened? So it said if you were registered by 1903, right, you were grandfathered in. Was Mr. Giles registered by 1903? Why was he not registered by 1903? Why did he not register? Why? Well, he went to go register before 1903, and what happened?
You couldn't make all qualifications.
No. The qualifications were in effect for 1903. He went before 1903. What happened to him? Nothing.
Your refusal basically.
They turned him away. So even though in 1902 the law was such that he was allowed to register to vote without these qualifications, they turned him away because he was black. The local Alabama officer, whatever his title is, right, said, no, sorry, we're not going to register because you're black. That is what he challenged, right? He challenged the fact that he wasn't able to get grandfathered in prior to 1903. Everyone get that? He was not challenging this elaborate scheme of having property and everything else. All that he was challenging was the initial decision to turn him away and not let him vote.
Right. He had been voting from 1970 until
Right, but he had to register under this new regime before 1903, and that they did not let him do. Right, Jason's point's fair. This was meant to disenfranchise a lot of people, right? Even if you had been voting since whenever, they were taking away your right unless you re-registered under this new system. Okay, so we see what the issue is here, right? They make this elaborate system which says if you're registered by 1903, you can vote. If not, have property. He tried to register in 1902. They turned him away because he was black, right? So Andrew, what did the court do here? How did they have to answer on this issue?
The court essentially said that I think about two things. One, that practically the judges
Couldn't enforce what law?
couldn't enforce the local election.
Okay.
to-
Good. Why could? Okay, so let's talk about the powers of equity, right? We have law, we have equity. Why could a court sitting in equity order the Alabama Board of Elections to give a voting card to Mr. Giles?
Because it has no means to enforce.
Ah, so here we get to the issue of remedy. We'll do the merits in a minute. We get to the issue of remedy. This is an opinion by Justice Holmes. And Justice Holmes will discuss that at length later, not one of my favorites. But Justice Holmes says very clearly, like, look, what are we going to do? We're a federal court. We can't sit in supervision of local election boards. Are we actually going to monitor it and make sure that they give out voting cards to every single person who comes to apply? He basically throws up his hand and says, listen, we can't do this, right? This is not what federal courts do. Okay. I want to fast forward a minute, Caleb, to Brown 2. What happens in Brown 2?
Brown 2, they determined, like you were saying earlier, the schools would be desegregated at like a fast pace.
But who would supervise it? No. Brandon, who would supervise the desegregation under Brown 2? Who did the Supreme Court say will be in charge?
State legislatures.
Oh God, no, they're not in charge. Juan, under Brown 2, who would be in charge of supervising? I mean, who's supervising it though? Who do you think? Which branch? No. Not the Supreme Court, but who? The lower federal courts, yes. The entire issue in Brown 2 was the Supreme Court said, okay, we've now spoken. We've now said segregation in schools can't happen. The lower federal courts are now responsible for supervising the schools. So it's very interesting. The very thing that Justice Holmes said cannot be done. He says you cannot have federal courts supervising local elections is precisely what happened in Brown 2. It's precisely what happened in Brown 2, where the Supreme Court said, all right, lower courts, you guys are the managers, and you keep the state legislatures in check and make sure that you're desegregating. Everyone get that? Okay? Yes, Connie.
I thought that tell me again when section 5.
Congress has to legislate. Congress has to pass laws.
Right.
Did Congress ever pass a law saying schools cannot be segregated?
Well, it says they should have the power to enforce that.
Yes, they have to pass a law.
Okay.
Unless Congress passes a law, Section 5 doesn't apply. So say if Congress had passed a law in the 1950s saying that all schools in the United States must be desegregated, they would have the power to enforce that law. But Congress did not pass that law.
Okay.
In fact, in 1954, Congress segregated its own schools in the District of Columbia, as we shall see, Bolling v. Sharpe. So Congress wasn't going to pass that law.
Would you say that this guy that wrote the opinion that basically talking about that Giles,
Justice Holmes.
he sounded so sarcastic when I read it. I don't think that he was trying to narrow his question. It was like almost like kind of provocative.
So Justice Holmes is an interesting fellow, and again, I am not a fan of his, but he was very much, how should I put this, a majoritarian. And I think one quote of his summarizes his jurisprudence very well. He said, "If my fellow citizens want to go to hell, I will help them get there." And he believed that. You can look it up. He said, with narrow exceptions, he believed that emphatically. And he thought that it wasn't for the court to ever stand in the way of majoritarian politics. He was a progressive in every sense. We'll do a case in about 3 weeks called Buck v. Bell. This is probably the most disturbing case of the year, which involves the effort by the state of Virginia to sterilize a woman they deemed incompetent. She wasn't incompetent, but they sterilized her. And Justice Holmes, in one of his opinions, said the state was free to sterilize a woman. And one of his most biting quotes was, quote, "3 generations of imbeciles are enough." The court found that she was an imbecile, her mother was an imbecile, her grandmother, all false, of course, but Justice Holmes wrote, 3 generations of imbeciles are enough. So the sarcastic sense that you perceived, I think, was probably a fair characterization. But I will defend Justice Holmes because he basically says at the end, look, we're not going to express any opinion on the constitutionality of this, right? He goes out of his way not to address the constitutionality of this decision. Again, this could have been much worse, right? Mitchell, how could this case have been worse? What could this case have said that would have been really bad? Like, what's like the worst case scenario? What was the worst case? Justice Taney comes back from dead, writes this opinion. What's the worst case scenario? Pretty much, yeah. The court could have said, so long as a law doesn't discriminate on the basis of race, all these other requirements, the literacy requirements, these property ownership, those are all fine. Had Justice Holmes given his blessing to these provisions, it would have been a lot worse. So again, not exactly a progressive opinion, but it wasn't regressive. It didn't, push the cause too far back. But the effect of this case, and this was in the book, it says, it quoted the, quote, virtual elimination of black citizens from political participation in the South. This decision, although it didn't actually say so, nullified the power of blacks to vote in the South. Gone. Because virtually every single Southern state imposed these types of requirements. So before, Wade, I said to someone, what's the usual remedy if someone doesn't like the way tax dollars being spent? What's the remedy usually? How do you impact your local government? How do you impact your local government? Voting, right? What can the African Americans not do now? Vote. So you see what happens, right? By taking away the right to vote, you're affecting the political process. That the court said in the Cumming case, oh, if you don't like how tax dollars are being spent, go vote for someone else. And oh, by the way, now you can't vote. So you see the box that Jim Crow creates, right? You effectively divest people of an education. You divest them of the right to vote to impact that education. And then you say, unless you own property, you can't do all these things. And how are you going to get property without a job and education? It's a cycle, right? But this was a very deliberate effort. So even though Justice Holmes, who again I'm not a fan, doesn't make any statements about this, he allows it to happen. Okay, we have a brief opinion, Marianne, from Justice Harlan, our friend, right? What does Justice Harlan say here? At the very end, it's a brief one. Louder, I can't hear you. Oh, did they omit it? Oh, I'm sorry. I read it. Okay, well, I actually read the real version of the case. It's not the. Okay, so in fairness, I read the full version of the case, not the omitted version, so I don't always remember what they cut out. Okay, so fine. Justice Harlan dissented, and he says, this happens to me too often, he says, the court has jurisdiction to hear the case, and he says, the plaintiff is entitled to the relief he wishes, right? He effectively says, this is unconstitutional. Okay? I'll mention briefly one other point Justice Holmes makes, which is kind of interesting. He says, he says, if this law is unconstitutional, right? If, I'm not saying it is, but if it's unconstitutional, wouldn't it be perverse to make someone comply with this unconstitutional law? In other words, if this law in fact is unconstitutional, why should the court be facilitating it, right? Why should the court allow Mr. Giles to vote under this unconstitutional law? Marion, back to you. What do you think of that argument, right? What do you think of this argument that if this policy is unconstitutional, we should allow him to vote under it? What do you make of that? You think Mr. Giles cared that he was voting under unconstitutional law? No, he wanted to vote, right? So it's this interesting issue of remedy, right? Would the correct remedy be to strike down the entire voting regime or allow him to vote within this unconstitutional program? Okay. And if it happens to the people in this case, what if the next person wants to come vote? He can't. He has to go to a lawsuit and sue again. In other words, by leaving up and by sanctioning this unconstitutional system, you effectively require every new voter to come bring a different lawsuit. And that's not very practical. You can't expect people to come to court for every election, right? All right, any questions on the case, Giles? Yes, ma'am.
Was it that the voting scheme was unconstitutional or just the way that it was applied?
What's the difference?
I don't know, I think like sometimes like when I have long books and maybe like just the law in itself, it's but then that it can be applied or not applied in a certain way that then it's like sort of, it discriminates.
Very good.
Classes.
So I don't think I've discussed this before, but there are two types of constitutional challenges, right? If you're going to challenge a law as unconstitutional, there are two types: facial and as applied. Okay, facial and as applied. A facial challenge means on its face, right? This law is unconstitutional. So let's take Strata versus West Virginia, for example, right? That was a law that said that blacks could not serve in juries. Juries were for white men, right? On its face, right? Paper, on the face of the statute, that law is unconstitutional. Okay? What about this law, right? And again, the court didn't reach, but we can pretend. Is there anything in this law, Jocelyn, that says people of different races can vote or not? Is there anything? But in practice, how does the law operate? Right. So what you would then bring is what's called an as-applied challenge. Saying, listen, the law itself is fine, but as applied to African Americans or people of different races, it's acting unconstitutionally. Okay. The facial challenges, right, are usually a lot harder because no longer do we ever have a statute that says you can't do this because of race. What happened in Jim Crow is said, all right, let's find ways around it. Let's put a property requirement. Let's put a literacy requirement, whatever, right? So you often had these challenges that were as applied, and you have to actually prove some sort of a discriminatory intent, that this law is actually designed with an intent to disenfranchise. And we're not stupid. Justice Holmes wasn't stupid. Anyone could look at this situation and go, what's going on? But again, the court did not want to reach that constitutional issue. So again, they kicked the can down the road, right? We have one on education. Now we have one on voting, where effectively some of the core aspects of our civil society are now entrenched with segregation. All right, any other questions on Giles? Okay. All right, so let's do the last case in this trilogy, 1908, so about 10 years later. Berea College versus Kentucky. And I should mention that Berea College, I've actually, I clerked not too far from where that was, and Justice Harlan, who dissented in this case also, was a native son of Kentucky. He was a Kentucky colonel. No, Colonel Sanders was actually a Kentucky colonel. It's an honorific title you can get. I actually went to his grave in Louisville. I left a bucket of KFC there. I actually did. I went to a KFC. They had one by. I left a bucket for the colonel. I thought, well, it's actually a funny story though. So this is true. Colonel Sanders founded Kentucky Fried Chicken, right? And one of these big conglomerates wanted to buy KFC from him, but he didn't believe in stock, so he wanted cash for the KFC, which was a really bad decision. So he sold his entire business and his likeness. There's a reason why I see those cartoon colonels now. They actually sold his likeness to the new company for cash. This was a mistake because after they sold it, it blew up to this massive global corporation. So he got screwed. He had very little money for a small Kentucky business. So he actually tried to compete with them and make his own KFC with his own image as Colonel Sanders. And KFC sued Colonel Sanders for using his own image to sell chicken. This actually happened. So he actually died a very poor man. And his original spices and all the recipes, this was owned by KFC corporate. Now it's owned by the Yum Food brands, which also owns KFC and Taco Bell. In fact, the basketball stadium in Louisville is called the KFC Yum Center. That was the most coolest name for a stadium. It's where the Louisville Cardinals play. Okay. Anyway, so that's my Colonel excursion. All right, let's go. So Madison, what were the facts in Berea College versus Kentucky? You said desegregated, right? That's right. It was a desegregated school, right? And background, Berea College was a Christian university, which was founded as an integrated school. It was a very progressive school for the time. Please continue. Okay. Good. 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 Okay. So this is a different case, right? This isn't a situation where the city or the county decides not to build a school for African Americans. This is a situation where Berea College was founded as an integrated school and that they were trying to offer education to everyone, right? So what did the school do? They decided to criminalize teaching people of both races at the same time. And this law, which Justice Harlan quotes at some length in his dissent, is very severe. It imposes penalties on the school for every single day that they're educating people of both races. It imposes penalties on the teachers who engage in this education. So this isn't just requiring state schools be segregated. It's going after private schools, right? And these were criminal proceedings, make no mistake. They could have been fined $1,000. That was a lot of money back then, right? For a small school dedicated to teaching people. Yep. And the statute was called an act to prohibit white and colored persons from attending the same school. Okay? There was no mystery about what this law was doing, right? Anyone who read this case would be very clear what this law was doing. Yet once again, the Supreme Court, in opinion, found a way to resolve this on very, 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 very narrow grounds, almost to the point where it doesn't make much sense, right? Daniel, what was the basis on which the court resolved, the majority of the court, 8-1 decision once again? On what basis did they resolve this case?
Well, I think they said that a state's representative has the right to amend it.
Yes.
And so they were free to amend it however they got it, and the school had to follow that.
Right. So this is really interesting. This is corporate law. You haven't taken any business association classes yet, but under business law, states can create corporation law, and they can grant charters to corporations to operate in a specific manner. So, I mean, these can be very simple requirements. You know, a corporation must have a president, must have a secretary. You have to file these reports with the states. You need to, treat your workers in a certain way to make sure that they're not abused, whatever, right? Generally, the state has a very wide latitude over their corporations. But here, they enacted a law saying that, okay, by the way, if you're a corporation in our state, which the college was, you're now required to comply with this law. We are effectively amending your corporate charter for you. We're amending it by law saying that you need to comply with this law. And the failure to do so requires you to pay fines. The same way if you don't file your annual, taxes with the state if you're a corporation, they'll fine you. Same here. If you teach white and black kids together, we'll fine you. And and we'll be fair. If you want to open up a school for people of different races, make them 25 miles apart, right? It's almost ridiculous when you think about it. But it's yeah, we'll be fair. Let's open a school 25 miles away, different campus, whatever, right? But the court accepts this argument based on corporate law, right? So, Luis, what is the actual holding of the majority? What does the majority hold?
Basically that there's a distinction between individual rights and corporation.
Yes. Oh, this is now we're okay. So, what are these corporate rights? Do corporations have any kind of rights?
I guess they have the right to actually prohibit from teaching black and white students.
Does a corporation have the right to resist that? No. So what's interesting here, and this is often conflated with all these arguments that corporations have no souls and they're not people. This may surprise you, but that doctrine does a lot of bad work, okay? So there was another case called Pierce v. Society of Sisters. We'll do this case in maybe about 2 or 3 weeks. The facts of the case were like this. The state of Oregon banned all private education. All private education. At the time, what were the only private schools? I want to guess. Catholic schools. This was based on anti-Catholicism. Anti-Catholicism was rampant in the 18 and 1900s. Rampant. People did not like Catholics, right? So they actually passed a statute which on its face banned private schools, right? But in reality, this was a way to get rid of, as applied, Catholic schools. So who brought the lawsuit? Not students, not teachers, but the corporation, the Society of Sisters, which ran the school. And the Supreme Court held there, which I think was actually correct, the mere fact that you're a corporation does not deprive you of the right to pursue your constitutional rights or your substantive due process rights. I think that was the correct holding there. Here, they hold in a very perverse application. The fact that this school is a corporation means they cannot be protected by the 14th Amendment. And if you're a teacher at this corporate school, by the way, you've also relinquished your rights to the 14th Amendment. So it's a very people say corporations aren't people. There are effects of taking that argument, and this is actually one of the cases. This is actually one of those cases Citizens United opponents don't like citing because it makes it look very makes a very shaky argument. But they say here, listen, corporations, you have no rights. So let me ask you this question, William. What happens if you were an independent teacher? You had a one-room shack, right? Could you have an integrated classroom in your one-room hut, somewhere in the log cabin in Kentucky? Would that be allowed? Oh, I'm sorry. I skipped over. I'm sorry. Oh, man. William. No. That's all right. You have William. What do you think? Could they do that? Limit it to a one teacher shack in the Kentucky log cabin? Would that be allowed to have integrated classes? No, but under this law, could the state fine a teacher working by himself and teaching independently with no corporate charter?
Yeah.
How? What do you think, Brett? Yeah, did you flip?
Yeah, no, he's not here.
Oh, okay.
I'm all, spread out.
Okay, yeah. Sit where you're supposed to, because I look at the truck with. If you're on the right seat, then I'm off.
The press being incorporated.
Yeah.
Penalize people that were incorporated.
Okay, so how could, I'll ask you the question I've been asking all class, how could this opinion have been much worse? What could Justice Holmes have said, or what could Justice Brewer have said to make this a lot worse? Rather than making this entire corporate, rights distinction, which doesn't make sense. What's like the tawny opinion here? Would be too far. What do you think? Anyone? What's the tawny opinion here? Yeah, Morgan. Not they would have to be. No. Let me ask this follow-up question. I'll jump back up top to Rob. Rob, was there any, according to the majority, was there any constitutional right to get an education? Or was there anything special at the fact that this was a corporation chartered to provide educational services? No. What about if the court had held, Rob, there's no right to education, period, and that therefore the 14th Amendment doesn't apply? That education is merely just like a social service, like the same way you provide garbage or trash collection, right? Yeah. So here's the issue, right? This comes up in Justice Harlan's dissent. Again, Justice Harlan's dissenting. The court could have said, there's no right to public education. There's no right to teach or learn. Who cares if the school punishes you for integrating it, right? If that was the holding, Brown would have been impossible, right? If the entire nature of Brown, which we'll do in a couple minutes, is that public education is so important, right? That would have been really bad. So again, the court didn't quite move the ball forward, but the damage was limited because the extent of this is that you had to actually pass a law and prosecute people for teaching an integrated classroom. Everyone get that? All right, Harlan's dissent isn't his opinion, right? Yes, okay. I read the full one, sorry. Hugh, what does Justice Harlan say in his dissent? Again, he says it alone, one by himself.
I think he talks about how the right to teach is like a natural right.
Oh man, what's this? Sorry, my throat's close. What's this natural right you speak of? What does that mean?
He talks about how it's like a law given by law.
Yeah.
Actually, for like a property for it.
Good. So okay, so a couple things about Harlan's opinion, and you're exactly right. Shelby, does Justice Harlan come out and say that this violates the protection clause and plus he's wrong? Does he come out and say that? But does he say this violates equal protection? Why do you think he does not say that this violates the 14th Amendment and plus he's wrong? Why do you think he doesn't bother wasting ink on that argument? What do you think, Lauren? Okay, good. He doesn't want to waste his time, right? If he were to go and write, we need to overturn Plessy, he already did that, right? He dissented. He made his peace. So what he does is he tries to attack it from several alternate routes. And Hugh mentioned one of these where he said you have a natural right to learn, right? Jonathan, where in the Constitution do we get this right to learn and right to teach? Where does this appear in the Constitution? Where might we get this from? No, I said in the Constitution. I mean, the pursuit of happiness in the Declaration, fine, but where in the Constitution might we get this right to education, the right to teach, the right to learn? Well, let me answer this question. What's the only provision in the Constitution that limits the states? What's when we're spending all of our time learning? Oh, come on. The 14th Amendment, right? What provision in the 14th Amendment may be understood to provide natural rights? On the screen, pick it up. Here. What provision in the 14th Amendment may be understood to guarantee some rights? Be more precise. Which clause? Section 1. These entire thing's up there. Elliot? Well, that's the right answer. That's not the answer the court said. So the right answer would be the Privileges and Immunities Clause. On slaughterhouse, the court slaughtered that clause. So that section's out, right? What are we left with? Not equal protection, right? Because equal protection is Plessy. Already in the Plessy doctrine, they rolled equal protection. So what are we left with? Due process. Due process. And here's the argument, which we'll spend probably after this topic about 3 weeks on. The argument goes like this, okay? The Constitution says states cannot deprive a person of life, liberty, or property without due process of law. Harlan doesn't come out and say this exactly, but what he suggests is that one of the liberty interests protected by the 14th Amendment is this right of education. That the right to teach and learn is so important in our concept of American society that it is one of the liberty interests that states cannot deprive a person of. Okay? This is one of the earlier instances of what became known as substantive due process. I've used this word before. What do I mean by substantive due process? The due process clause doesn't merely protect procedure, right? If they want to kill you, they need to give you a trial, right? That's procedure. If they want to take away your property, they need to give you a trial, right? What substantive due process says is that there are substantive or material components of liberty that no amount of process will suffice. In other words, if you're keeping a kid out of school based on his skin color, no trial will allow you to do that. No process will get you there. That these rights are not procedural, they are the opposite of procedural, which is substantive, okay? So what Harlan's discussing here is an early instance of what became known as substantive due process. Although there are problems with this doctrine, which we will discuss much later, which is, how do we know that the word liberty means education? Where do we get that from? Where is it in the history of the 14th Amendment that education means liberty? And if that's the case, keep this in mind for Brown. If you do have a liberty interest in education, isn't Brown easy? Isn't Brown saying, oh, we don't need equal protection? These black children have an interest, liberty interest in education? Done. Wasn't Brown an equal protection case? Brown was. What about Bolling v. Sharpe, the companion case for the District of Columbia, right? We'll do this in a few minutes. But if you notice, the Fifth Amendment, which controls the federal government, does not have an equal protection clause. It does have a due process clause there. So effectively, Justice Harlan's dissent, finding a liberty interest in education, is what the Supreme Court adopted in Bolling v. Sharpe to find that students in the District of Columbia had a right to education. Everyone get that? It's a convoluted route, very convoluted. But by explaining from Harlan that there's a liberty interest in education that the states cannot violate, that's how he resolves it. And that's how the court resolves Bolling v. Sharpe. That was a lot, I know. We'll do more. We'll do this again later. But I want to flag for you the fact that Harlan's dissent raises a substantive due process issue and does not try and ground education as a matter of equal protection. Questions? Yes, ma'am.
I was wondering, Harlan's dissent is sort of reference like religion and stuff.
Okay, good. That's my next point. Go on.
Are there any cases where people try to go around, like, instead of relying on the 14th Amendment, they rely on the First Amendment?
Well, answer your question, Jocelyn. In the year, what year was this case? 1908? Did the First Amendment apply to the states yet? No. But here Harlan also, he's so ahead of his game, right? I discussed this doctrine called incorporation. We'll do this later when we discuss the Bill of Rights. But originally, the Bill of Rights only applied to the federal government. Arguably, I think this is correct, the 14th Amendment was meant to extend the Bill of Rights to the states. What did the court say in Slaughterhouse? No, 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 this only protects federal rights. So until the 1920s, 30s, 40s, and 50s, the provisions of the Bill of Rights did not control the states. If Alabama wanted to open up a state-sponsored church, they could have. If Alabama wanted to punish Catholics, they could have. But Harlan, and you're exactly right, makes all these references to freedom of religion, freedom of going to church, right? How does he get there? Does anyone know? Anyone think a guess? How does he get there saying that all these religious liberty interests are in play if the First Amendment had not yet been incorporated? What's Harlan saying here? You want to guess? Anybody want to take a guess? He is anticipating the incorporation doctrine. He's effectively saying, the word liberty, this doesn't just mean a right to education, which I kind of pulled out of the thin air, right? He's saying the first provisions, the first 8 provisions of the Bill of Rights are liberty, freedom of expression, freedom of religion, the right to trial by jury, the right to grand jury. Harlan alone anticipated that the 14th Amendment would embrace the Bill of Rights to the states. There was another case called Hurtado versus California, where California refused to have a grand jury indictment. You know, a grand jury is to indict someone. California refused to have one. Harlan said, listen, we have this word liberty. We have the 14th Amendment. States cannot violate the provisions of the Bill of Rights, including freedom of religion. So again, Harlan was like 30 years ahead. This is why I'm such a Harlan fan. He was 30 years ahead of his time. He anticipated the entire incorporation doctrine of where the Bill of Rights would apply to the states. And eventually he was right. And decades later, the court said, yeah, by the way, the First Amendment applies to the states. States, you can't sponsor religion. You can't punish people based on their faith. Everyone get that? So Harlan's opinion effectively was focusing on the due process clause. So you have these liberty interests to education. You have these liberty interests in free expression. You have these liberty interests in freedom of religion. And these are things the states cannot violate. His opinion was grounded in what became known as substantive due process. Questions? Put your hand up or no? Okay. Harlan also faults the majority for ducking the issue. He says, quote, in my judgment, the court should directly meet and decide the broad question. Right? He's like, listen, we're not stupid here, right? We've done this now a couple times. You have the Giles case, you have the Cumming case, all of which he was on. He's like, let's actually decide this issue. But he knows that if the issue was to be decided, he would lose 8-1. And the court may reach a result that's probably worse than what happened there. Okay? So based on the substantive due process right and these liberty interests in education and liberty interests in religion, Harlan would find that this statute is unconstitutional. Okay? So any questions on Berea College? Okay. So believe, yes, ma'am. Well, the dissent did, the majority didn't touch it. The majority opinion, all it said was that the states are free to amend corporate charters. That's it. It was a very narrow opinion, again. You get, understand? Any other questions on Berea College? There's another case which is not in your book, which I know you didn't read, but I did. So it's called Buchanan versus Warley, W-A-R-L-E-Y, Buchanan versus Warley. And the facts were like this. The city of Louisville, where I lived prior to coming to Houston, passed a law segregating the city. I'm not talking about segregating schools. They segregated the city, saying people of one race can live in these neighborhoods and people of a different race can live in these other neighborhoods, separate but equal, right? Why did the city pass this law? Well, the city said, we want to prevent racial strife. We want to prevent riots. We don't want people of different races mingling in their neighborhoods. That'd be terrible, and things blowing up. So effectively, they legalized ghettos. I mean, this was not too dissimilar to what Hitler did. I mean, it's in the ballpark. Okay, so there was a court challenge, right, where a person, I forget which race is which, but I think a white person wants to sell the home to a black person, or maybe the other way around. I can't remember. But they challenged it, and the city basically blocked the sale of the home, saying, under this law, you cannot live here because you're of the wrong color. So interestingly enough, the buyer brings a lawsuit. He does not bring it under equal protection. Again, under Plessy, this was good law. He turns instead to the due process clause of the 14th Amendment. And what does he say? I have a liberty interest in what's called freedom of contract. Freedom of contract. The idea that I can make whatever contract I want. If I want to buy this property from this guy, then I can buy this property, right? If you remember, the Civil Rights Act of 1866, which was the precursor to the 14th Amendment, specifically said that the freedmen, the freed slaves, had the right to contract. The state could not infringe the rights of contract. And what did the Supreme Court hold? You're right. That your liberty of contract is so strong that the state cannot prohibit you from selling your land. It was not an equal protection case. It was a due process case. Okay? And this doctrine often gets a bum rap in a case we'll talk about later called Lochner. But in several respects, as exhibited in Harlan's dissent in Berea College and in Buchanan versus Warley, that the due process doctrine actually promoted civil rights. Because if people have the freedom to buy and sell land, or people have the freedom to teach where they want or run the college they wish, that means there's less government intervention. So because they couldn't overturn Plessy, they went about it on the side with these due process arguments. Okay? So again, it wasn't your book, but Buchanan versus Warley, W-A-R-L-E-Y. It's a good case to keep in mind. Yes, sir.
So what sort of due process would be required for that for the city to block that from sale.
Well, that's what substantive due process means. No process could ever justify this. So we go back to Magna Carta, right? We're in the 800th anniversary of Magna Carta. And one of the provisions of Magna Carta says no person shall be deprived of his property unless by the judgment of his peers or the law of the land, right? And what that means is generally if the government wants to do something bad to you, they need to give you a trial to give you the appropriate process. But there are some violations that are so egregious that no trial could ever justify it. I'll use the example of Buck v. Bell, the sterilization case. Is there any trial that you could imagine that would give enough process for a woman sterilized against her will? Is there any amount of procedure that could ever justify the state ripping out a woman or severing her tubes? I think most people in this room will say no, right? There's such an egregious act that no process works. This is the idea of why substantive rights exist, right? But again, substantive due process is very controversial for saying, well, we don't want judges reaching to the air to create rights because that gives us rights to abortion, rights to sodomy, rights to same-sex marriage, and we'll do those cases later. Because once you start saying, well, the government can't do this without any process, that places a severe limitation on the police power. To due process later, but I want to tee it up now because it was actually an early tool used to fight for civil rights, and it's one which is not widely appreciated because people don't like it because of Lochner, or they don't like it because of Roe v. Wade. They say, oh, it's just evil. But it had, had some high points in the earlier days. Okay, any other questions on Berea College or Buchanan versus Worley? No? All right, let's move on. So after the Berea College case, the Supreme Court started to inch closer to Brown. And again, this was done based on the leadership of people like Thurgood Marshall, who worked at the NAACP Legal Defense Fund. And they had a very strategic plan, right? They knew that their end goal would be public school desegregation. That was like their, their pot of gold into the rainbow. That was their final step. But they recognized that they couldn't go there on day one, that they had to move incrementally. So one of the cases they did was actually one involving Houston. So I'm sure some of you know, in Houston is a school called the Thurgood Marshall School of Law, named after him. It's at Texas Southern, not South Texas, which drives me nuts because everyone gets it confused. But this school was actually created. They don't know why TSU had a law school. Anyone know the history there? No? Yeah? Yes, sir. So the case is called Sweat v. Painter. Sweat v. Painter. An African-American tried to enroll at UT Austin, and they said no. So under the doctrine of Plessy, what did the state of Texas do? Let's build another law school. Let's build a law school at TSU, 2 miles away from here, right? But in a case called Sweat v. Painter, the Supreme Court basically held that this was not constitutional, right? That it wasn't sufficient to build a separate school for black law students, that there were certain, quote, intangibles of going to law school, right? But this decision, again, was very narrow. It didn't say you have this right to education. It didn't say that Plessy was overturned. It was actually a very narrow decision tied to law school and why law schools were so important. And again, all the judges in the court were former law students or professors, as it were. So this was one of the cases beforehand, right? But they realized that ultimately the goal was public schools. So let me take you a little bit of a walk through the history of this case. One of the most important attributes of the NAACP was strategy, okay? They recognized twofold. The change they wanted could not happen overnight. They couldn't go to the court on day one and say, overrule Plessy. That was a losing argument. They also couldn't go to the state capitol in Alabama or Georgia and say, guys, repeal your segregated school statutes, right? That was not going to work either. So they developed an approach that would chip away at it one bit at a time. And they decided that one of the first aspects to focus on was education. And the reason why they focused on education was this wasn't employment. This wasn't, public parks. This was something which every single person had under state law a right to get. In every state, there's some sort of right to education. Texas has one as well. So they identified a series of cases in different states, and this was deliberate. They want as many cases as possible to trickle up, so to speak, to the Supreme Court. So the first case was a girl, her name was Linda Brown, from Topeka, Kansas, and this is her family, the family. This is a pretty cool photograph of all of the plaintiffs in Brown. And there were actually cases brought from South Carolina, Virginia, Delaware. By the way, Delaware, you don't think that's a segregated state? No, Delaware, right? It was, and Washington, D.C. And the idea was by bringing cases with, and again, I'm not exaggerating, they chose really cute kids, and this was deliberate, right? They wanted people to go on the front page of the newspaper and attract sympathy, right? They wanted very cute kids who would make people say, oh, you know, but this was deliberate. When you're ever doing civil rights litigation, your first rule is find a favorable plaintiff, okay? Find a likable plaintiff, because it gives you that extra incentive as a jury or something else. If people don't like your plaintiff, you're in trouble. So to give you an analogy, right now with the Obamacare case that's been argued, you may have read about this, the plaintiffs are not particularly likable, that they've been making a lot of statements about Obama's a dictator and all these other things, right? Not the best plaintiffs. So again, these really cute kids, they were young, they were trying to go to elementary school, and they were not allowed. So as it turns out, these were the students lining up in I guess, height order, as you do in elementary school, if everyone remembers that. I was always towards the back. So Monroe Elementary School was the segregated school at issue, okay? And the segregated school was about 21 blocks away from where Brown lived. And actually, it's an interesting story. The school today exists as a national park. It's not a functioning school anymore, but they've actually converted the school to a public park. And you can actually go there in Topeka. If you're ever in Topeka, take a trip. And they actually have signs. See, it says white this way and colored this way. Okay? And it's a historical museum. The white school was 3 blocks away from where Brown lived. So she's saying, listen, I want to go to the school 3 blocks away, not 21 blocks away. So she's actually a good plaintiff for a lot of reasons. Also, one thing which I don't need to stress too much, but it should be recognized, these children who signed up for this case, whether they appreciate it or not, put targets in their backs, right? They and their families put bullseyes on their homes. They were at risk of being lynched. People blowing up their houses, burning down their houses, right? This was not just like, oh yeah, let me go sign up to a plaintiff. This was a dangerous job because there was such antagonism, hostility to these cute little kids. Okay. So this is actually her class photo where she went to school. Okay. So again, the facts of the case were like this. It's very simple. In a number of states, there were segregated schools. Under the prevailing law, what do we have? We have Plessy, which says as long as the schools are separate, they're okay. One of the cases involving Delaware, the Delaware Supreme Court actually said, well, they're not equal, right? The black schools are underfunded. But virtually every other court to approach this said, you know what? These schools are by all measures equal. We're not going to invalidate them. Okay. The chronology of this case is almost cosmically eerie. And what do I mean by that? When this case was first argued in 1953, it was argued under the Chief Justiceship of Fred Vinson. Okay? Fred Vinson was inclined to uphold segregation. Had the case been resolved in 1953, you would have had a divided opinion upholding segregated schools. Fred Vinson died a few months later, suddenly. President Eisenhower made a recess appointment, and we discussed the recess appointment clause. He made a recess appointment to the Supreme Court. He did a recess appointment of the Chief Justice. You imagine today that you don't want a recess appointment to the National Labor Relations Board, right? Eisenhower made a recess appointment to the Chief Justice of the United States. Okay? And he appointed a guy named Earl Warren, who was the governor of California, a Republican, but a fairly, as it turns out, quite liberal Republican from California. This changed American history in a way it's very hard to appreciate. Because had Brown come out the other way, I don't know what would have happened with the civil rights movement. It would have been a serious blow. I mean, it's hard to say. But by appointing Chief Justice Warren, the case was re-argued at the request of Justice Frankfurter. Because Justice Frankfurter says this opinion has to be unanimous. This cannot be 5-4, right? This cannot be a divided opinion. That this was of such magnitude, such importance, that the court had to speak with one voice. Okay? What would have happened, Plumman, what would have happened if this was a 5-4 decision?
Probably more of the same report.
Right. The court decided that this had to be unanimous, right? But Plumman, let me ask you a follow-up question. What's the cost of unanimity? I've asked this question before. To get everyone in a room to agree, what usually ends up happening? A lot of compromising. This decision is full of compromises. I'm sure when I assigned Brown, you're all excited, like, yes, I'm going to read this awesome opinion about equality and overturning Plessy versus Ferguson and this beautiful language. None of that is in the case. I mean, the version you read, was it 3-4 pages? I mean, the actual version is a tad longer, but not much. It's a compromise. And in many respects, too much compromise. But they needed to get the votes of all 9 justices in order to make this a unanimous decision. Okay? So, Michael, what is the whole thing of Brown versus Board of Education? I know they say that the schools can't be segregated, but what's actually the way to get there? What's the test? What's the reasoning here?
Well, you know, separating between based on race, that it's obviously in the sense that creates a sense of freedom.
Okay.
They didn't want to fight
So is the entirety of this case about public education, or about employment, or public schools, or the public hotels or roads? Okay. The only issue that they tackle in this case is public school education. That's it, folks. You do not get a decision overturning Plessy. You do not get a decision saying that separate is not equal. All those things you were taught were actually wrong. None of that happened. It happened later, but it didn't happen here. All the court says, all they say, is that in public education, you cannot have segregation. Underwhelming, right? But what does the court say, Demi, about history? You know, what do we say about the original understanding of the 14th Amendment? What do we say about that? Does the history of the 14th Amendment tell us one way or the other how to understand segregated schools? Does the history of the 14th Amendment, what the framers thought, how it's understood, should that tell us one way or the other how this case resolved? Is there any clear evidence there? Why not?
Because education has always been important, and as far, I don't think that the time, I agree the time has changed and how they were talking about it, but I don't think that the 14th Amendment really addresses that.
All right. What, Sam? What did they say about the framers? Was there any clear evidence there? What they thought? What did they say about the evidence? Chloe? What does the history of the 14th Amendment tell us? Is there any clear evidence one way or the other of what the answer is? No. It's inconclusive. The court says that there were some people at the time of the 14th Amendment who wanted wide-ranging desegregation. And there were some people at the time of the 14th Amendment who wanted wide-ranging segregation. The answer, they say, inconclusive. We don't know what it means. Okay? As it turns out, this question is actually really complicated. So one of the common facts cited, that was mentioned in Plessy, in fact, is at the time of the 14th Amendment, and for long thereafter, the District of Columbia, which was managed by Congress, had segregated schools. How can it be, they argue, that the Congress that controlled the District of Columbia had segregated schools, that the 14th Amendment prohibits it? And there's another article by a professor who became a judge named Michael McConnell, who argues that at the time of the framing and shortly thereafter, people were very eager to desegregate schools. That was the general gist, right? So the originalist argument cuts both ways. And the court says in very famous language, we cannot turn back the clock. We cannot turn back the clock. Whatever happened then, we don't know. Whatever, right? We're not going to resolve that. So move on from any kind of originalist or looking at the original understanding of the 14th Amendment. And they go through all these other cases. They go through, Cumming versus Board of Virginia, Board of Education. They go through Sweat v. Painter, right? And what do they say then about Plessy? Ian, are they in a position now to say that Plessy was right or wrong? Why not? Why are they not in any position to say Plessy's right or wrong? What do you think, Connor? Uh-huh. Oh, no, they were separate schools. Monroe's a segregated school, and the other one was somewhere else. Sumner was a white school. They were different buildings. She wanted to go to the school designated for only white students. She didn't want to go to a separate school. She wanted to go to the school closer. The school is 3 blocks away from her. Good. Right. So what happens if under Plessy the schools actually are equal? Let's say that the one 21 blocks away from her and the one 3 blocks away. What if they're actually equal? Same funding, same teachers. Aren't those schools okay? Okay, good. That's what I wanted to hear. They're not tackling the separate but equal doctrine, right? Christian, why do you think they're not tackling the separate but equal doctrine as a broad issue? Why do you think they didn't do that here? Can louder, please? Well, I'm sure they wanted to, but why didn't they? Why did they avoid the issue? Why didn't they tackle this broader problem? Yeah, why didn't they just say separate's not equal, period, done? I know that's what they did, but why they want to narrow the rulings in that way? What do you think, Krishna? Maurice, what do you think? That's exactly right, okay? The judges in this court were very political savvy. Earl Warren was a governor of California. He was the governor of California, a big state. He understood how politics work, okay? And I think the judges recognized that if we go and say separate's not equal, we're going to have a massive mess of states disregarding federal law, disregarding the courts, and how the heck are we going to enforce this? So instead of actually going through the 14th Amendment, they made a very narrow decision based on the psychological impact of children based on segregated education. And on its face, right, that doesn't really apply itself anywhere else. If the case was only about segregated education, does that tell you whether you can have a segregated water fountain or a segregated lunch counter or a segregated swimming pool? No, you would need subsequent decisions. So in a very similar fashion, Morgan used the word manipulate, right? In a very similar fashion to how these other cases focus, oh, this is about taxing, and oh, this is just about corporate law, right? The court's able to shape their doctrine to avoid disrupting too much stuff too quickly, right? So Brandon, what were these psychological effects? If you look at footnote 11, it's probably one of those famous footnotes in the history of the Supreme Court. What are these psychological factors discussed here? Okay, tell me more. Yeah, right? I was never at that table. Explains a lot, right? Right. So the court goes through, and again, footnote 11 of the opinion is probably one of the most famous footnotes in the Supreme Court because it basically cites all these social science articles. And these articles make the point that having segregated schools is counterproductive or harmful to education. That when students are sitting, at one table and then the whites are sitting at another table, that makes them feel inferior and they can't learn well. And because learning is so important, it's such an important aspect of our society, to the extent that this policy gets in the way of learning, it's unconstitutional. Yes? Ah. So reminders of slavery and segregation, right? Yeah. So effectively, they're not saying that the fact that there are separate schools by itself is unconstitutional. What violates the Constitution is that this policy has an impact on children learning. Okay? That's the holding of Brown. That's it. Yes, sir.
Robert Ford was criticized for exactly what he's saying now, like the constitutional reasoning.
Well, what do you think here about the constitutional reasoning of Brown? I mean, and I want you to be honest. Put aside the fact of what's going on. If you were to write this on your legal writing memo, right? This kind of analysis, how do you think you would do? Yeah. Anyone else? Yeah.
I agree with them, but it's their best because he's not gonna, I think they realize after all the cases that have been before, the decisions before show that every time I try to use a constitutional, argument, it's going to slow down. So I might as well go with this more humane and more good so that we can argue this. I think what you're saying, I think the reason that the analysis is also psychological effects is because they invoke equal protection laws. So they okay, equal protection, that's important analysis of not equal process of these things. Look at the effects of segregation, all these tests, all these studies. They show that students learn equally. They're not learning the same, they're not as intelligent, they're just basic books, something like that. Inherently, that's not equal protection. So I think that kind of
So let me ask you a follow-up question, and this is purely devil's advocate. What if 20 years later, new studies released showing that, in fact, students learn better in single racial education or single gender education? Does that now change the meaning of the Constitution? Why not? If this was...
because it's simply linked on education.
Yeah, but I'm telling you, the study is conclusive that single racial education is more productive, that people learn better when they don't have to worry about it. And all the social studies you see what I'm getting at, right? Yeah. Social science is malleable. I don't mean to criticize psychologists, but in the same way that our work is malleable, social psychology is malleable. And I think, you use the word weakness, the doctrine who was criticized as being a cop-out, right? Instead of actually addressing the constitutional issue, which would have been really easy, they make up this argle-bargle, it's just a squeeze word, about social science, right? And it was roundly criticized at the time. I think one guy said it was who said it was a gibberish. Well, who said it was a I forgot which professor said it, but it was one very prominent law professor said this was gibberish, right? how do we accept this, right? How do we accept an opinion that we all know is correct? I mean, if you look at this picture, it should bring a smile to your face. This was Linda Brown sitting on the courthouse steps with the newspaper saying the High Court banned segregation. This is a picture that makes you happy, right? But the reasoning that they got there leaves so much to be desired. So much to be desired. And more precisely, because they didn't address separate but equal, it took another 20 years before we actually got to the actual eradication of various forms of segregation. It took some time. Yes, ma'am. I'm sorry, say it again, please. I didn't hear you.
While they were in that school, were they still
So let's talk about what happens afterwards, right? That's Brown 2. I'll get to it in a minute. But the short answer is concrete swimming pool. The short answer is entire civil disobedience. The short answer is school district shut down. But we'll do Brown 2 in a couple minutes, right? But I want to focus still on the reasoning of Brown, right? Everyone agrees this was the right outcome. But should it trouble us the fact that you use such reasoning that, you know, isn't very good, based on social science, footnote 11, right? Yeah.
We talk about after these cases in the notes, there's 3 different ways to interpret this clause. That was one of the basic housing science interpretation. There was also that segregation is intrinsically discriminatory or it's subjectively discriminatory. So how are you supposed to, which way are you supposed to attack it?
Where do you get that argument from? I know you read it, but where does that argument come from? Is that in Brown? But I know the Brown wrote that, but where do they get that from in the law? So the issue here is, right, there are lots of social science theories about discrimination or whatever, but courts have a written constitution they have to expound, right? And invariably they have to bring in different values to get to the results. To what extent should judges be bringing this social science research, right? Hector?
I was just gonna say that courts always make policy.
Are they supposed to? Ah.
Through the tradition, yeah. They, courts always look to
Is that a good thing?
I mean, it's worked so
Is it a good thing when courts make policy decisions involving segregation, eugenics, abortion?
why would this case be any worse by policy?
Well, the question, should they be applying it in any case? In other words, and this is a broader issue, and I'm mostly playing devil's advocate here, but these are issues that were riling state capitals and that were basically tearing the country apart. And unelected judges suddenly say this. What would you say to the argument? Let the political process play out. Let the political process play out. Let states desegregate their schools. I think the response to that is they weren't going to do it. And if the answer is they weren't going to either way, what difference does it make that you have a court decision? All right? Let's move on to Brown 2, right? In Brown 2, the court basically said, oh, sorry, at the end of Brown 1, like, well, we have this case, right? You can't have segregated schools. Oh, by the way, we're not going to tell you to desegregate your schools now. Let's go re-argue this. Let's go invite the Attorney General. Let's go invite all these states to submit arguments, right? Lauren, what happens in Brown 2?
Basically, Brown 2 report said that we're going to, the lower federal courts are now in charge of implementing this, and they could do it in a timely manner. And they say that they have to make it prompt and reasonable start towards the compliance.
Okay, and this is effectively an answer to Hector's question, right? When the courts decide to make policy or whatever, there's no obligation that people listen, okay? And I will go back to Dred Scott, right? Roger Taney made policy in that case. Oh, he did. He made policy how Africans could never be citizens. He made policy that the Missouri Compromise was unconstitutional. He made policy about how no matter what you do, you can't get rid of slavery, right? He was making policy there. What did Abraham Lincoln say to Dred Scott? No, I think you're wrong. And I think everyone in this room celebrated that, saying, of course, yeah, you know, Go Lincoln, right? Go Abe. But the problem becomes, how do you know that you can say no to courts? So in the aftermath of Brown 2, where they basically said all the lower courts are required to supervise desegregations, there was massive civil disobedience. And I don't mean this lightly. School districts shut down. In Virginia, all the schools shut down. This case here, Palmer v. Thompson, which I discussed before, involved a swimming pool in Jackson, Mississippi. A federal judge ordered them to desegregate the pool to allow people to swim. And rather than comply with the desegregation order, they filled it with concrete. They just got rid of the pool. This was the pool. Okay? 1957, right? This is 3 years after Brown. I discussed this case, I think, in the first or second day of class. Little Rock High School, Central High School in Little Rock, Arkansas. I visited there a few months ago. The school said, we are not going to desegregate. They basically ignored a federal court. And then President Eisenhower mobilized the 101st Airborne to escort these 9 children into the school. When I said before that Linda Brown put a target on her back, there's a reason those guys have guns, right? There were mobs that were trying to harass and beat these people up. That's why they had to be escorted into school under gun supervision. And actually, the aftermath was they didn't even go to class because it was so dangerous. They spent the entire day in the principal's office. They couldn't even leave the principal's office. They had to go through like a side door or something. Okay? 1963, right? The court said the University of Alabama has to desegregate, has to integrate their schools, right? Governor George Wallace, a segregation, said segregation today, segregation tomorrow, segregation forever. He stood in the courthouse doors in Tuscaloosa and blocked access. President Kennedy ordered the Alabama National Guard to confront him, right? These are these moments where policy meets the road. And what you'll find is the court's order by itself didn't mean a damn thing. A federal court in Arkansas ruled that the Central High School must desegregate. They ignored it. What forced them to do it? President Eisenhower was sending federal troops to escort children to school, right? A federal court ordered Alabama to desegregate, Roll Tide, right? They ignored it. So what actually happened? The President Kennedy sent federal troops to escort students into the building. So we realize here how precarious courts are, right? They can't enforce their judgments. And unless the political process is getting behind them, not much will be done. So for all of the celebration of Brown, right, it was only implemented with, quote, all deliberate speed. And believe it or not, 60 years later, we're now 6 years later, there are still federal courts supervising schools and desegregation. Still. There's one case going on in Louisiana that where I'm sure there are others. Right? 6 years later, they probably had 3 judges live and die during that period, and they're still under supervision. Okay? What really changed was a law we've discussed before, which was the Civil Rights Act of 1964. The Civil Rights Act of 1964 required no discrimination on the basis of race in place of public accommodation, okay, and later in employment, okay? If a person was discriminated against, they could bring a lawsuit and hit people where it hurts, their pocketbooks, okay? This is what really broke down segregation. Brown was an important step, and I don't mean to trivialize it at all. But I think you can realize very quickly the limits of the court's reasoning, and especially because they made it so narrow that it only applied to federal, to public schools. Okay. Now we want to talk about manipulating a docket. What happened after Brown? Every single time a case was brought, say one involving public beaches, or golf courses, or city parks, or bus systems. Do you think the court had another 10 hours of argument and brought all these states in? No. They issued what were called per curiam opinions. Per curiam means these brief, unsigned opinions with no argument, where the court basically said, oh, by the way, you're segregating your beaches. We're going to reverse this to the lower court to decide it in light of Brown. You want to segregate your parks? Okay, we're going to reverse this and send it back to consider in light of Brown. Wait a minute, Josh, right? Didn't Brown say nothing about this? Wasn't Brown only education? Yes. Even though Brown was only about education, through a series of these short per curiam orders, the court quietly expanded the reach of Brown far beyond education. So if you want to talk about the weak reasoning of how they limited only to education, that was only a short-term deal. And very quietly, without any arguments, they kept broadening and broadening to other images. So the Supreme Court, in many respects, was at the forefront of desegregation in the 1950s and 60s. But what actually made it happen was the president and the Congress, by enacting civil rights laws, that actually put teeth in it. So for all the wonderful things about courts making policy, unless the political system's backing it, it won't go very far. Okay? And this will be an issue that comes up again when we discuss abortion with Roe v. Wade, sodomy with Lawrence v. Texas, and this year we discuss gay marriage. Perfect semester to teach it, probably the last one I can do it this way. So these are issues about what is the role of the court in our society, right? If you accept Brown, you also accept Roe. Can you have one and not the other? Tricky question. We'll discuss this later when we do abortion. Okay. Questions? Yes, sir. Why not what?
Who's going to take international law? Who's going to take, like you said, Congress why not? Why wouldn't the judges do it? Try to put the onus on Congress?
Well, couldn't Congress have passed a bill? Well, let me ask you a question. In 1953, right before Brown was decided, this is a good exam question, actually. Could Congress have passed a law requiring schools to be desegregated? Could Congress have passed a law under the Constitution saying all public schools in the United States must be desegregated? That law would never have passed, right? I'm asking, could Congress have enacted that law? What constitutional basis, Maurice, would Congress have relied on to pass that law? Which provision? What gives Congress the power in the 14th Amendment? Someone said it? Section 5, right? Maurice, remember the civil rights cases? What did the court hold in the civil rights cases? What could Congress not do? Yeah. So effectively, Congress tried to require public accommodations in states to be segregated. And what did the court say in the civil rights cases? Nope, 8-1, Harlan dissent, right? So I ask you the question again. Could Congress have passed a statute in 1953 requiring schools to desegregate? Absolutely not. That would not have been a constitutional law in 1953. I don't think it would have been constitutional afterwards, but it's dubious, right? So in many respects, Congress was made up half of southern states, so nothing was getting passed anyway, right? It took executive action, so to speak, to do this. But Congress could not have even taken the action necessary to segregate the schools in the 50s. It was only through the judicial remedy and enforcing it by sending troops to enforce it, right? So there's no good answer here, right? I don't mean to make light of this, but there were not a lot of good options. And I think the court recognized we're in this for the long haul. So let's do Brown 2. Let's take our time. Let's stretch this out. This may take 20 years, whatever, but eventually we'll get to the point where the segregated schools are gone. Okay. Other questions? All right, so today, look, we have these cases, right? We have Cumming, we have Giles, and we have Berea. These are cases where the court, to use Morgan's word, manipulated the docket and tried to avoid the tough constitutional ruling. And then we go to the seminal case of Brown, right? Brown. which we all thought was this majestic opinion, which doesn't really do much by itself. It just says deliberate speed. But then what takes place later, the political process, is what brings us to where we are today. All right, any questions? All right, have a great day. I'll see you all on Tuesday. Oh, God, yeah. After.